Good evening. My name is Bob Liff, and this is the CUNY Forum, a monthly town meeting that brings prominent New Yorkers together with faculty and students of the Edward T. Rogowsky Internship Program in Government and Public Affairs. In a political system that seems set up to protect incumbents at all costs, some have said that lawmakers leave office only one of three ways: death, indictment, or becoming a judge. We are here to look at that third option. The public generally becomes familiar with particular judges when they become central actors in the criminal and civil trial dramas that play out before them. But a series of scandals, largely generated out of Brooklyn, has shown a light on the ways in which those judges assume the coveted benches, and those scandals, which have seen several judges removed, several more indicted, and at least one jailed, have brought to the forefront a passionate judicial reform movement that has tried to change that system by which the judges are picked. While the federal system is fairly straightforward in that trial and appellate judges are nominated by the president and confirmed by the Senate, New York State has an astonishing array of courts on the local level. There are criminal court judges selected by the mayor, civil court judges who are nominated in partisan primaries, and Supreme Court justices who are nominated by judicial conventions controlled by whatever political party happens to be in power in that county. Remember that Supreme Court in New York is the trial level as opposed to the top court as it is in the federal system. The top court in New York State is called the Court of Appeals. The controversies came to a head this year with a decision by a Brooklyn federal judge, John Gleeson, declaring the judicial convention system unconstitutional because it essentially placed picking Supreme Court judges in the hands of party functionaries. Judge Gleeson ordered Supreme Court judges to be picked in partisan primaries this year, as in the civil court process, though he later stayed his ruling after complaints it would be too disruptive over too short period of time. While all this might seem hyper-technical, it actually goes to the heart of the branch of government where the least accessible government officials exercise great control over our freedom and our property. We are joined by four players in that debate who take sometimes overlapping views of the issues involved. Deborah Goldberg is the director of the Democracy Project at NYU's Brennan Center, which served as lead counsel on the case decided by Judge Gleeson. Dennis Hawkins is director of the Fund for Modern Courts, which has long been at the forefront of these debates. Jerry Goldfeder is a Manhattan attorney who lectures on election law at Fordham University and has worked with state and local Democratic officials, including candidates running for judge. And Paul Wooten is a Brooklyn-based lawyer with a citywide practice focused on civil rights and ballot access issues. Deborah, let me start with you, since you know the Brennan Center was the lead plaintiff, was the lawyers for the lead plaintiffs. In Judge Margarita Lopez-Torres' case, who has actually since been elected to become Brooklyn surrogate. Why did you bring the case?
We brought the case because it's a core issue for the Brennan Center to generate an inclusive and effective democracy. And under New York State's Constitution, the justices of the Supreme Court are supposed to be elected. The reality of the situation was that they were handpicked by party leaders who really controlled who became justice and who didn't. And in our view, that was undemocratic. The second reason we brought the case is because we were very concerned about diversity on the bench and diversity in the legislature. And although the convention system has been useful for some districts in Manhattan and Brooklyn, there's been fairly good diversity as a result of the convention system. If you look at the state as a whole, minorities are really not being allowed to get to the bench, and they have very little access to the bench, and we think that needs to change.
Dennis, should we switch to an appointive system? I mean, you guys look at the various ways that the judges are picked. Is it an appointive system, an elective system?
Right. Fund for Modern Courts is an organization that's 50 years old and has long advanced what we call a commission-based appointive system. And in such a system, the chief executive appoints people to the courts only after an independent judicial qualifying commission passes on the qualifications of the individual. What's critical in this kind of a system is that the commission members should be representative of the community they represent or serve. They should be independent, and part of the process should be that only a limited number of well-qualified individuals are passed on for appointment. We advocate 3. An appointive system is one way to get to a well-qualified, representative, and unbiased bench. But it's not the only way, and even our 50-year-old organization is looking at alternatives in light of the Gleeson decision.
Jerry, in the case of Brooklyn and Manhattan, both of them had screening panels which were independent to varying degrees. Would the kind of system that Judge Gleeson wants to set up undercut the ability to pick judges fairly? Why would you object to that, to Gleeson's recommendations, Gleeson's decision?
Well, the interesting thing about Judge Gleeson's decision is that it was supposedly premised on the argument by the plaintiffs that having a direct primary would be more democratic. Democracy is a word that's thrown around by various people to try to persuade others that their side is right and just. The convention system that we have has resulted in tremendous diversity. You take Manhattan, for example. We have more African Americans, we have more Latinos, we have more Asians, we have more women on the bench because of the judicial convention system. What worries me is what Judge Gleeson is attempting to do is change the system that will have the effect of bringing big money into judicial races. We see that in other states. That worries me a great deal. I don't think that we want to decide who is on the bench based upon how much money they have or how much money they can raise.
Paul, Ms. Goldberg, Deborah was talking about diversity on the bench. In fact, it seems, is it a telling fact that it's in Brooklyn and Manhattan where you do have the greatest amount of diversity on the bench? Is that an accident, and is that something that is Gleeson's cure worse than the disease, in the sense that you would undercut the ability to keep that diverse bench?
Well, I've been representing candidates for election for some 28 years, 28 years. I've represented judges, presidential candidates, congressional, city council, you name it, same as Jerry has done. And it's been my experience that the Judicial Convention in Brooklyn has produced more diversity in the history of New York State than in any other time in the history of New York State. That isn't by accident. It's interesting enough, you know, we have a county leader, Clarence Norman, who has since been indicted.
Since been convicted.
And convicted. Right. But approximately 15, 20 years ago, when Meade Esposito was in charge of Brooklyn and others, and we had a Judicial Convention, and African Americans and Latinos were locked out of the Judicial Convention based on party politics, nobody cared. There was nobody running around saying, well, you know, we got to talk about ballot access, we got to talk about equality, we got to talk. Nobody cared. They ran a party ship. As time went on, when African Americans and Latinos, through population shifts and through redistricting, got control of the districts so that they had the means to elect judicial delegates, and now they have significant input and, in some cases, control over the Judicial Convention, now all of a sudden the Judicial Convention is bad. Now all of a sudden this is not the way to do it. Now all of a sudden we want to change that, and the result of that could be the effect of eliminating one of the most effective means of equal representation in the court system in the history of New York State.
And I want to add to what Paul has said. As a general proposition, people of color have less money than white candidates. There was a civil court race in Manhattan about 20 years ago where a African-American lawyer was the candidate of the political clubs, of the Democratic Party clubs, for civil court. And he was defeated by a wealthy white woman who outspent him, I want to say 10 to 1, 100 to 1, I really don't know what the figures are, but overwhelmed him. She's a terrific judge, but it made it impossible for a good, qualified African-American from Manhattan to win. I think that Judge Gleeson did not take account of that.
I think Judge Gleeson is taking account of that, and we're very deeply concerned about those issues, and we have been studying them across the nation. And it is absolutely true that people of color do not have the resources in elections that white people typically have. But there are solutions besides just throwing your Constitution to the wind. I mean, right now, there's a requirement that there be elections in this state. If people in the state don't believe that elections are a good thing, they need to change the Constitution, and there is a way to do that. If people want to have their judges picked by party leaders, they can certainly do that. But right now, we have an elective system, and there are ways to address the money issue as well. We have public financing systems. Under public financing in New York City, we have a very diverse city council. There's public financing for judges in North Carolina. There are ways to get around some of the very real issues about elections without just throwing them away.
Yeah, and I think it's important to remember that Judge Gleeson really didn't decide that that elections was the way to go. That's the default position. He found that the conventions were undemocratic, both to the voter and to the people who wanted to participate, the judicial candidates. Having no other option except the Constitution, which says Supreme Court judges should be elected, he defaulted to what exists. One of the things that modern courts did way back in 1977 was change the election system for the New York State Court of Appeals, our highest court of appeals, and introduce this concept of a commission-based appointive system. I don't think that we are particularly happy with the way that it's working, and the flaw in it is that this commission recommends as many as 7 individuals for each vacancy, which gives the governor wide latitude in terms of the appointment. So that I agree that now is the time for the legislature to decide whether they're going to take control or allow this to happen in the courtroom. And the legislature right now has an opportunity to make decisions about what kind of system they want to have: appointive, elective, primaries with public financing. And I would like to see, and I think modern courts would like to see, the legislature make decisions rather than have this decided.
Let me just make one. You know, I always kind of declare my potential conflicts of interest. I worked in the past with the Brooklyn Democratic Party at a time in defense against some of the attacks on the system, although I haven't done that for a number of years, and I'm just confused now.
Can I just address one little point here? I don't want the viewers to misunderstand. The system that we have is an elective system. We do elect civil court judges. We do elect Supreme Court justices here in New York. The plaintiffs brought this lawsuit because they didn't like the way we were electing them. Elections are not for summer soldiers. The candidate who brought this case tried to win and didn't win. She was able to get on a ballot in another way, but she wasn't able to get the Democratic Party nomination. Well, you have to be persistent in politics. You have to be resilient in politics. You have to try to go out and get support. We do have elections. Judge Gleeson just doesn't like the kind of elections that we have.
To kind of cut to the chase, there's politics in elections. There's politics in elections to the legislature. There's politics in the election to a judgeship. Going to an appointive system, for example, where you would have Governor Pataki, let's say, make the appointments, and then however they wanted to be disposed of, whether it was through legislative consent, whatever way it would be, is a political system. So, I mean, is the goal to take politics out of the selection of judges and to limit and to allow lawyers? As the only non-lawyer here, I can take gratuitous shots at lawyers. War is too important to be left to the generals. There's an argument that this kind of question is too important to be left to the lawyers. To remove politics and put it more in the hands of lawyers kind of removes the general populace from this kind of a process.
I think that the first point is that modern courts, and I think a lot of people in this panel are concerned about money. Where does a judicial candidate get money from?
Gets it from lawyers.
Of course. And who appears in front of the judge?
Or they get it from themselves.
Right. Most of them get it from themselves.
But in other states, people are taking money from lawyers who are appearing in front of them. And if the goal of whatever system is designed is to have an impartial judiciary, how does a judge be impartial when half of the lawyers or some portion of them have contributed to his campaign?
Well, the Code of Judicial Conduct deals with that. Judges who are candidates, whether they're incumbents or insurgents, judges who are candidates cannot directly ask people for money, and they're not allowed to know who contributes.
And do you believe that to be true?
For the most part, that is true, because most judges are ethical, even when they're candidates. And if you think that that's not true, if you think judges are violating the ethical guidelines,
I don't know.
Okay, well then we'll leave it at that, because that would be a harsh statement about judges. I believe that most of our judges are very qualified and conduct themselves according to the ethical guidelines of the Code of Judicial Conduct. They're not supposed to know who contributes to them.
I agree that they're not supposed to know, but it's hard to believe that they don't know.
Well, you set up a committee.
But to the extent that they do know, there's also an obligation that if an attorney comes before them in which they know that they're supposed to recuse themselves, or the attorney is supposed to disclose.
Sure.
And I was before a judge 2 days ago, in which I represented a candidate in opposition to this judge. And the first thing the judge said to me when he got on the bench, I opposed him. First thing that Judge Gerson said to me when he got on the bench was, "Mr. Wooten, do you wish me to recuse myself and send for another judge?"
I hope you said yes.
Actually, I said no, it was a simple adjournment. But that's an illustration of what I think this judge understood the canon of ethics to be. Actually, he had no obligation to do that.
But there is
but I'd like to make another point about appointments, because aside from the Gleason decision, I don't think the Judicial Convention is perfect, and some of the issues raised in the Gleason decision are significant and important. But as far as appointments are concerned, from my point of view, if we look at the record of how certain appointing authorities appoint people of color to the bench in New York State, it's abysmal. I mean, I don't even want to talk about Pataki. What do we got? We have, in the entire Court of Claims, we have one African-American judge in the entire state system for under Pataki. That's disgraceful.
But yet,
and to think that the appointed system is less political than the public system. Actually, it's more political.
It's just different.
But it's 10 times more political, because all of it is insider back dealing. Right. I got to talk to this person. I got to know this person. I got to know that person.
That's why the appointive system, as it exists in New York, has to be changed as well. And there has to be a different independent judicial qualifying commission, as suggested by Dean Ferrick and the Ferrick Commission.
I saw the Ferrick Commission, and I don't see any difference.
It has to be something that allows for diversity of the membership pool of the commissions. And Assemblyman Weinstein, for instance, bill that passed last year, provides protections or incentives to appoint people to the commissions who represent various communities, women, minority groups, and those are the kinds of things that modern courts believes could improve the appointive system to a place where representative individuals, people represented of the community, are appointed.
Who would appoint the people?
Yeah.
I like the Manhattan system.
But who would appoint the people to the appointing committee?
I like what Manhattan does, as a matter of fact, the Manhattan Democratic Party, that has this kind of double blind, that the party leaders appoint individuals who represent either a bar association.
No, actually, the way it works is the party picks the groups.
Right, and then they
the groups pick the
individuals. I like that system. I think that would insulate and take away some of the politics from the appointing authority.
And here's why it doesn't. And it's because that even though you have what have been termed community people on the board or on the screening panel, and I know because I've been on I'm one of the few people that have survived being on the Kings County Democratic Party screening panel. What happens is that decisions are made in secret, and the rules require that you can't even discuss what decision makings you've made. As a matter of fact, on many of the panels, even when you represent a bar association, you can't discuss with your appointing body what decisions and what went on in the meeting.
Right.
So to the point of disclosure, that's an issue. The second problem is many of the commissions now want to narrow down the number of appointments. For example, if you have 10 people who are running for Supreme Court, my view is you got 10 people, the panel's supposed to pass on all 10, and then they let the public know, and the public choose among the 10 who they want. But there are movements out there, And I know Manhattan does is they narrow it down. They don't, when 10 comes in, they may narrow it down to 5 or 3. So the panel is making the decision who's eligible to get to the voters.
And now the party leaders are making the decision who's eligible to get to
Let me follow on that, because one of you.
Well, that's not not true.
It is
really that's not true. And I'll explain. And if you want, I'll tell you exactly why it's not true.
Because that's the claim, that the party leaders control this, and all you need to do is go to these judicial conventions. You go to a judicial convention in Manhattan, and the party leader doesn't control very much of anything. It's a wide open process.
They're done in 20 minutes, and there's no contest.
Then you've never been to a judicial convention in Manhattan, where there are hundreds of people involved in a process for several weeks.
It's very dangerous to generalize from
where
Manhattan.
Candidates are vying for the support of these various delegates, and you go to a convention, and I don't want to say anyone could win, but mostly anyone could win if they're qualified.
Okay, but isn't it also a fact, in Brooklyn in particular, since I'm most familiar in Brooklyn, that people come to the judicial convention and come through the panel, even if there's many people who come through the panel, and their political pedigree is critical. You know, what club they're in, who they, I mean, whether they've run before, whether they've worked with the party. Isn't that kind of political pedigree part of the qualification? And to argue against, because I agree that limiting the number of people that panel puts before the judicial convention or any other body, and this is my kind of generic anti-lawyer feeling, is kind of allowing lawyers to control who's going to run lawyers. I mean, that's a very convenient thing.
The panel is more than lawyers. The panel is not just lawyers. It's community groups, and they pick lawyers, they pick non-lawyers.
But the question is, doesn't your political pedigree count to an inordinately large degree compared to, let's say, your...
Give me an example.
Well, I mean, that when I was a reporter covering this stuff in Brooklyn, I mean, I always knew what clubs the particular candidates came out of, and which club.
Okay, but that's not. But hold on, but wait a minute, but just a second. But that's not true anymore. I wish that was the case. But that's not. That's not true anymore.
Take a look at Margarita Lopez Torres, who was the plaintiff in this case, and what happened to her. Okay, she successfully ran for civil court judge
with the support of the county organization.
With support of the county organization, she decided she wanted to be on the Supreme Court. What happened was, when she became a civil court judge, she was told by the county leader that she should hire a particular person for her court attorney. And when she refused to do that, they very effectively blocked her from ever becoming a Supreme Court justice again. We had testimony at the trial about the nominating conventions from 1994 through 2000, and the defendants in this case could not come up with a single instance where a party leader opposed a candidate and the candidate still made it to become onto the general election ballot. The party leaders may not be able to.
Margarita Lopez was on the general election ballot herself. She herself was on the general election.
Not as the party nominee.
But she was on the ballot. It's called an election. She had an opportunity to run and win.
Right.
I will tell you one of my questions about Judge Lopez Torres, because I covered some of this, and I covered the 1996, I believe it was, Brooklyn Democratic Judicial Convention, where there was a huge floor fight with Assemblyman Tony Genovese, the late Assemblyman Genovese, leading attacks on Clarence Norman, and that she, as a sitting civil court judge who wanted to be on the Supreme Court, aligned herself politically. She made a political choice to join a political struggle within that convention and lost that struggle. So I mean, I think that in terms of the broadest.
We don't want to take politics out of elections. As long as we're electing judges, that's what politics is.
I'm not suggesting that we take them out. I'm saying that we bring the voters in. Right now, the voters do not choose.
I agree.
We have a system in most of the districts around here that are very heavily dominated by one party or another. The general election is not where the election takes place.
But that's
it's like the white primaries.
But that's wait a minute. But that's a fact of life. Okay, I mean.
Right, but that's why the primaries need to be meaningful.
No, but I agree with you to the extent that the Judicial Convention is not perfect and there needs to be some changes. Okay, fine. But to come in here and argue the argument that, well, the reason we should do this is so that we can make primaries meaningful, that's just not a political reality. If you look throughout New York State, most counties are heavily dominated by one party versus another.
Right.
Okay, I have instances, I have clients in Nassau County, and if they're not down with the Republican Party, they can't get a job. because the predominant
Not
enrollment. No, well, okay, let's not say that publicly. But to the extent that the dominant party in certain counties are either Republican or Democrat. In Brooklyn, the dominant party is Democrat. Even in Manhattan, to a smaller degree, the dominant party is Democrats. So it is not surprising.
To a smaller degree?
I mean, it's a smaller plurality.
Let me ask a question.
But to the extent that the dominant party decides the largest number of judges is a political reality of enrollment. It's not a reflection of collusion. It's not a reflection of lack of ballot access. As a matter of fact, it is the result of ballot access. In New York City, the primary is the election. And to try to say, well, we want to change it to the general, it's just being undemocratic.
I'm not saying that.
You could say that about the way we elect assembly people and state senators and Congress people. The entire state is gerrymandered, and that's true in every state.
But that's my point.
It's a fact
I agree with
of American political life.
That's why the party selection process is so key, is what I'm saying.
She had an opportunity, the plaintiff in this case, had an opportunity to go out and get support. As Bob was saying, she aligned herself with one faction that lost. She nevertheless went to try to get support among delegates. As I said before, politics is not about summer soldiers.
Let me ask you also.
Let me just say, I have a chart here of how many signatures a person has to get in order to get delegates on the and then get elected. Sorry, and you know, in let's say in Brooklyn that we've been talking about, you need to get 12,000 signatures. They need to be evenly spread out, 500 signatures per assembly district. If you were running for a state senator, you only need to get 15,000.
How many signatures per assembly district?
First of all, that's not true.
It's 500 signatures.
As I said, 500 per assembly district.
But that's not true. To get on the ballot, if in order to elect delegates, you don't have, in order to be a competitive candidate, you don't have to elect delegates from every single assembly district. You just don't have to. And you don't have to fill slates from every single. And back in as late as 1982, I was with an organization called the Coalition for Community Empowerment. And we actually did an engagement policy against Meade. We actually ran delegates in the African American communities back in 82 and 83. Well, Meade went crazy. But we didn't choose to, in order to be competitive and to negotiate with Meade about who should get through the convention, you don't have to run them in every single assembly district. That would be absurd.
No, but you have to run them in a very substantial, a very substantial supermajority.
Because you're running against the party and the party leaders. But that's not true.
And you're talking about money.
How
much money do you think it's going to take to run these people?
Well, first of all, it is significantly less to get delegates in an assembly district, which is what? I think it's 117,000 mean.
38, or so let's say
it's 130. It's 138 for the council, and it's about I think it's about 117 or 119 for assembly district, as opposed to running across the entire Brooklyn borough. I ran for DA last year. I put out petitions to get 25,000 signatures throughout the entire borough. I know what that cost is. I represented judges last year who spent somewhere between $200,000 to run for civil court countywide.
Right.
And I don't want to throw names around, but we did their financial disclosure statements. We did their petitions. That's an awful lot of money. Actually, it would have been cheaper for them to run smaller organizations in what may have been a majority, not supermajority, but in a majority of assembly districts so they could engage people when it came time to the convention. The issue here is when you get to the convention, is to be able to have the delegates or delegate slates advocate for you at the convention. You don't need every single delegate slate in the second district. And what is that? What is that, 40? No, it's like 22 districts, I believe it is. It's 22 districts in the second
Staten
department.
Island and Brooklyn.
Staten Island and Brooklyn. I'm going by the number of district leaders. But because it's one slate per assembly district. You don't need every single assembly district. You don't even need the majority. The point is you want to have enough delegates so that they can go in and advocate, and there's some give and take at the convention to do that. Now there are factors at the convention that work against that, and I think those things should be changed.
Let me just, before we go to a question, and this goes to my question of whether Judge Gleason's cure is worse than the disease that he's trying to cure. In my experience of covering elections, there is no screening process to get on the ballot for civil court. Anybody can. Anybody who's I think you have to be a lawyer for 10 years in order to qualify. And in fact, there have been significant numbers. I don't mean one or two, but significant numbers of judges elected to the civil court who have been both backed by the organization and frankly, in more numbers, challengers to the organization who were found unqualified by not by the Brooklyn party policies, committees, but by the various bar associations. So it's exactly the kind of quality control that you're talking about that you lose in a civil court style election.
Absolutely.
I mean, so is this disease in that sense worse than the cure?
Yes, and you know, one of the things.
I mean, is the cure worse than the disease?
I think so, and I think one of the things that's important, and when I talked about modern courts evolving somewhat, the political realities is that neither the Senate nor Assembly are very enthusiastic about an appointment system. Modern courts has been impressed with the work of the Farrer Commission and impressed with the concept of independent judicial qualifying commissions. And it seems to me, and I think to most of our members, that as long as you have that system in place, whether it's an appointive system or an elective system or even a convention system, it would go a long way.
Would you, under that kind of a system, limit the number of people who could get on the ballot? In other words,
oh no, you can't do that.
Right, I'm saying
you can't do that.
Right,
but the public would know who was rated as
why
qualified.
Why would the public
or unqualified.
know more under that kind of a system than they do now in a city where even congressional elections don't get much coverage in terms of the media reality?
Because one of the proposals of Farrick and that OCA is backing is stronger voter education and getting the word out about who is qualified and who is not qualified. And there's going to be a lot of effort into that because, as Deborah said, the important thing is to involve the voter if there's going to be elections in this whole procedure.
It's going to be your opponent who tells people that you're unqualified.
That's right. Absolutely.
And in certain parts, in certain places, that's important.
Absolutely.
I know we're not here.
But to the extent that, you know, the reason I'm leery about screening panels is we've got the Association of the Bar, and I'm a member. Association of the Bar has a great screening panel. But even screening panels make mistakes. I represented a candidate who was found unqualified. I represented her. We went up on appeal. She was African American. We went up on appeal. They reversed. Okay, only because it was time to do that. Right. The following year, I represented another candidate who was found unqualified. She was running against an incumbent. There wasn't time to do the appeal because they did the screening panel so late that she didn't have time to do the appeal. Right. And she was literally told by a member of the panel, well, you know, I'm supporting the incumbent.
You know, Paul raises this point.
She won the election, but the fact remains is that when she ran, you know, there's all over the place by the Association of the Bar, she's found unqualified. As a matter of fact, the Association of the Bar finds you unqualified if you don't participate. So if I'm running for judge and I decide not to go to the Association of the Bar, I want to go to the Metropolitan Black Bar panel. I want to go to the Women's Bar panel. Instead, the Association of the Bar puts on their website that I'm found unqualified. They don't say unqualified for non-participation. They just say I'm unqualified.
I'm a member of the association, too, and I don't think that the association is the kind of independent judicial qualifying commission that modern courts is talking about.
Okay,
we want something different.
That's good.
We want something different.
They're the most powerful bar association in the city.
I'm an active member of the Association of the Bar of the City of New York also. And you raised the question. We're not here to talk about this tonight, but you raised the question about groups determining who's qualified. That's a very subjective standard. It shouldn't be, but it is.
Yeah, there have to be standards.
I would like to depend upon the voters to make decisions about who they want, which requires voter education.
With this is, how do you run for election as a judge? Do you get in front of the public and do you say, I'm tough on crime, I'm going to lock up the criminals? How do you really have an election?
Well, you know, I'll tell you exactly how.
Part of what I believe, and I think, you know, some good government groups believe, is that a judicial election, if that's the procedure, is not the same as an election for assembly or senate or for governor. You're not representing people. You're trying to get people to choose someone who is qualified, representative and impartial. So how do you run?
Well, I'll tell you exactly how.
You
tell people what you've done in the past to reflect who you will be in the future. So to the extent that I've spent 10 years in the corporation counsel's office doing contracts, and I haven't done anything, then people might say, well, what qualifies you to be a judge? Right. But to the extent that I have been out there with, say, a public law firm, or I've been out there with a public interest group, I've done pro bono work, I've done civil rights cases, I've done education cases, I've done 30 cases before the Supreme Court, and I've done 20 cases
do you
before
think
the
it'll
appellate
stop
division.
At that, if there are elections, that it's just going to be a resume, or is somebody going to do what judges have done of standing in front of a jail cell and closing it and having
happen here, though?
It happened in New York in the 70s.
It will happen.
It will happen.
It will happen as soon as we
states.
decide. It will happen as soon as we decide that the only way to elect our judges is through money. And here's the way we're going in New York.
That's the real problem.
This is the way we're going in New York.
That is the
and I'm
real
not so
problem.
sure that's not bad by general election. But right now we're moving in a direction where in New York State, money is everything.
I agree.
Nobody looks at your qualifications. It's all about the money, how much you can generate.
On the other hand, you know, there are. I show videotapes that Deborah lent me a few years ago, and I haven't returned them yet, to my law students in Fordham Law.
From other states, right?
From candidates running for judge in other states. They're obscene, these ads. But on the other hand, the Supreme Court of the United States says that just because you're running for judge, you are not stripped of your First Amendment rights. And I think they're right.
Excuse me, let me just let Deborah go, and I want to go to a question from the students, please.
Well, I guess one point I want to make that is to swing back a little bit. I think that we are, unfortunately, very much mired in our experience in New York City, in Brooklyn and in Manhattan, which I think is the best case scenario for this system. When you start moving out of the metropolitan area, and even outside of Manhattan and Brooklyn to a very large extent, you really don't have the same system. You don't have the very diverse screening panels, and you don't get the very diverse results. And again, I brought with me this chart of the 3rd, 4th, 6th, 7th, and 9th judicial districts. And in these districts, there are absolutely no people of color on the bench.
Of these upstate districts?
These upstate districts. There are 81 seats among these 5 districts, and there's not one person of color.
Those are the Supreme Court?
But those are the Supreme Court.
Well, what about civil court?
No.
What about civil court,
but
where there are direct elections?
But let's take a look at that. Before you do that, would you hold that up again? Just take a look at that. We're talking about most of those reflect county, right? County-wide.
These are the districts.
The districts.
The judicial districts.
And most judicial districts are either a compilation of 2 or 3 county or 1 county.
Right.
If we change this to go to a county-wide system where people have to get on the ballot, do you think an African American is going to be elected in the 4th where the voting age population is 7.4%?
Minority.
Okay. Or in the 6th where it's 7.4%? Or 12.0%, it's not going to happen. No. Even if we adopt Judge Gleason's suggestion in these upstate districts, you're not going to get a minority elected.
I promised I would.
It's impossible.
Well, can I just make one final point? The 4th district, there are no women judges in the 4th district either. And I do believe that we are at least 50% of the population. So there ought to be some.
I don't know what the population, but it's important to know. It's important to note, and I haven't done this on the basis of sex, but I have done it on the basis of civil rights. In New York State, we have a very polarized system, particularly in New York. That's why we're under the Voting Rights Act. You have African Americans tend to vote for African Americans, whites tend to vote for whites. And even African Americans will vote for whites, but whites never vote for African Americans. I don't know what the ratio is as far as women voting for women. So I don't know what that result would be, but you make a very good point.
The truth is, you're right, but it's also true, unfortunately, it's also true in the Assembly, in the State Senate, in the City Council, in the Congress of the United States.
Let me go to a question from the students. Tell us your name and the campus you're from.
My name is Louis Gaida, and I'm from the Brooklyn College Graduate Center for Worker Education. And I'm actually glad that you just came back to the question of diversity, because that's what my question's about. I see, you know, looking at state commissions who are appointed by elected officials like the governor and the House and Senate leaders, there's just a stunning lack of diversity. We look at the Hospital Closing Commission with 18 people who've been appointed to make decisions about our healthcare system. You've got 2 women and 2 people of color on a commission of 18. Clearly unrepresentative. I was wondering if any of you knew in more detail how it breaks down, what percentage of the judges on the state level and the local level are women and are people of color, and what can we do to really start to address that question, because it's fundamental in having people who are representative of the demographic diversity of our city and state to make good decisions.
Do you have the data with you?
I have some of the data with me. I do have the data for just for the Supreme Court justices, which are the only ones that are at stake in this particular case, for all 12 of our judicial districts. And there is not a single district in the entire state where the percentage of judges is as high as the of judges of color is as high as the minority voting age population in that particular district. There are a couple of districts where it's very close. In Manhattan, there's 50% voting age population and 44.7% of the justices. Very close. In Brooklyn, it's 56.
Brooklyn and Staten Island.
And Staten Island.
Because that takes in both, right.
56.8% of the minority voting age population, 34.6% justices. In the Bronx, 82.3% minority voting age population, 41.7% minority justices. Now, obviously, in the 5 districts that I mentioned before, where there's none, the percentage is 0. And in the remaining districts, there's, with exception of Queens, Queens has a 64% minority voting age population, and a 31.6% minority justices. The rest of them don't go above 7.7%.
Is it telling to you that in both with the 2 districts being the Brooklyn Staten Island district, the second, and the Manhattan district having the closest relationship between the minority population and the percentage of Supreme Court justices minority, and that both of those use screening commissions, and the fact that the state Democratic chairman was talking about taking basically the Manhattan system, not the Brooklyn system, and taking it statewide throughout the party in an effort, I believe in some sense, to blunt the anticipated impact of the Brennan Center lawsuit. Does that suggest to you that perhaps extending that kind of a system statewide would accomplish some of the things that you're talking about?
He suggested it because it's worked so well. It's worked so well in Manhattan. You're talking about Denny Farrell, who's the county chair in Democrats in Manhattan,
as well as
statewide. It's worked so well in Manhattan in terms of diversity and quality of the judges that he wanted to make, he wanted to expand it throughout the state.
But these systems, whether it's an appointive system or it's appointment by the party leaders, they work for diversity if the people who are part of them care about diversity.
Right.
Okay?
But wouldn't the political impulse, this is where I think that politics sometimes gets a bad rap, wouldn't the political impulse tend towards inclusive-ness?
Depends on who you are.
This is especially in a Democratic county. I'm not sure that's the case in upstate Republican counties, where I think that the Brennan Center with the Judge Lopez Torres decision is probably much more of a dagger at their heart than it is even within the Democratic precincts of New York City. So does that make sense?
I'm not sure I understand what you're asking. I mean, if we could be sure that the commissions that would be set up,
that the political impulse is, in essence, encourages diversity, because, one of the geniuses of the Democratic Party.
No. But here's why. But it's not the political impulse. It's the fact that in Brooklyn, in the past 20 years, you've had huge gains, and you have African-American elected officials, and you have voting rights districts. That's why the Voting Rights Act is so important. You've got, the 57th, 56th, 55th. You've got the 40th. You've got these are assembly districts, which
of course, northern Brooklyn,
right in central Brooklyn. It's not by accident that you have 2 voting rights congressional districts out of 4.2, I think, because Nadler comes in. That's the .2. But to the extent that you now have You have African Americans, you have, that includes Caribbean Americans, you have Latino Americans all throughout the borough who are elected on a local level. They in turn support and local judicial delegates so that when you go to the convention, there is some dialectic about people of color being elected.
That's right.
Without that, you wouldn't even be close to that 36%. And the 36% is skewed because in Brooklyn, you've got about 2.7 million people. But the second judicial district covers Staten Island. Right. Staten Island's got 400,000 people, and what's it got, 25,000 African Americans? It's certainly not more than 30.
Take a look at the Bronx, right? The Bronx has 82% and only 41% in the justices. Now, if you have a voting age population that's 82%, there's no way that you're not going to do better
but look how it's grown.
In an election than you are in an appointment.
You look at the Bronx. The Bronx is a great example that disproves your case. They had a judicial convention, I'd say about 20 years ago, and there were 2 incumbent white judges. And the county organization threw them out and backed African American. I believe it was African American, could have been Latino, I'm not certain as I sit here, but people of color in their stead. White incumbent judges. They were fine judges to increase diversity. Right. Sometimes politics works in a way that's beneficial to the people who the leaders represent.
But we're getting 50% of what we could be if the electorate were actually going by their...
But you can't go purely by voting age population or as a reflection of political power. Because there are all sorts of institutional barriers that go to why a person is counting as voting age population, but they don't participate in the process. Voting age population at this point in time actually counts immigrants, you know. We're counting immigrants in the census, but those people aren't registered to vote for a lot of different reasons. Right. So you've got these inflated figures about what's voting age population, and your suggestion that if we go to this elected system, this voting age population will participate, that's not true.
Let me, I've been ignoring the questioners. Yes, sir.
Yes, my name is Kenneth Sullivan, and I'm from the Brooklyn College Graduate Center of Work Education. A few moments ago, you mentioned voter education, and I would like to ask the panel, how do we achieve voter education, especially in regards to like the commercial broadcast networks, where basically on TV is the coverage of our voter system is relegated to like the hours where people are not watching, or what are your recommendations of how do we achieve voter education?
Yeah, as a matter of fact, the Chief Judge of New York, Judith Kaye, has convened a symposium conference on May 17th, which will bring together community people, media people, and people who are interested in this particular issue. And there's going to be developed a plan to make it more relevant what it is that judges do. Our organization tries to do voter education about the judiciary, and one of the ways that I deal with it when I'm talking to people is I try to put a face on what it is a judge does. If we just talk in the abstract, it's meaningless. If we start to talk about a judge decides who has custody of your children, a judge decides whether your severely injured child gets money from somebody who has crashed into him, a judge decides whether you will go to jail or not go to jail. So one of the things that we try to do is a little bit put a face on this. I think the judiciary is the third part of government, and we don't pay enough attention to it. If we start paying attention to it and we start putting a face on what it is that judges do, how it impacts on your life, I think people will perhaps be more interested.
I'm sorry, go ahead.
There also have been some efforts around the country where people have been very concerned about exactly this issue to try and develop educational materials for people. So, for example, in North Carolina, where they now have public financing for their appellate court judges, they also have a voter guide that goes out to every registered voter that describes what judges do, and it describes who the candidates are in their own words, so people can get a little bit more information about who they are. There are also organizations around the country, like the League of Women Voters, for example, who develop websites so that you can, again, get for free, just go into the library, go onto the computer, and you can get information about your local judicial candidates. It's not broadcast TV, but it's
this is where I try to keep my skepticism from slipping into cynicism. The clutter of information in a city like New York. This is not the case upstate, I don't believe, where a judge is a much bigger deal and there's a lot more attention. You know, where one congressman, for instance, may cover 28 counties, and here we have 10 in one city. You know, you can't get coverage for legislative elections, whether in the federal and the state level. And I don't know how realistic it is to believe that you can cut through that clutter to get the kind of attention on judicial elections that, or any kind of judicial attention other than the occasional scandal that, winds up getting a good deal of coverage. I don't know if that's...
Well, it's a problem only because, in my experience, people find out about judicial elections from either the candidate who's running or their opponent. Okay?
Or their political club, or the political club in their area, which will have a judicial candidate on a palm card when you show up at the vote.
Which is the candidate. I count that as the candidate. So the people who are supporting the candidate. It is a problem, even to the extent that I think in the Fair Commission, the court, Judge Kay, when she was talking about Rule 150, wanted to put out a voter guide. It was in that proposal. Yeah. She talked about putting something on the web. The only problem with that is there's a huge... I don't remember the exact amount, but I've heard numbers as high as 40% of families in Brooklyn are not on the web. So they can't go to the web to get the League of Women Voters information. They can't go to the web to get the Judith K report. They just don't. Sure. They're just not, for whatever reason, they're not wired in. It's a big, big problem. Voter education as to who's running, what is the rule, what is their role, what is the job is important. The only person who's ever been able to make a dent in that is probably the City Council voter guide under campaign finance, which is pretty well put out there. Right. But other than that, it's really the candidates, and that's unfortunate.
It's a problem not only in judicial elections. Nobody knows who their assembly candidate, their assembly representative is here in the state. You ask people in this audience who their state senator and their state assembly person is, and I doubt that. Maybe this group will know, but most people won't know the answer. Of course, we don't say, well, therefore they should not be permitted to elect their representatives. It is incumbent upon us in a democracy to try and figure out and try to get as much information out to the voters. And if the web isn't the way to do it, and then we need to really provide public financing so the candidates can do it, and we need to come up with other creative strategies for making sure that the voter can make an informed choice. We don't just remove the choice from the voter.
Why is, basically I believe that there is this low visibility, and because many people don't know who's running for judge, and they will get a palm card as they walk into a voting, into their polling place, and it'll include judicial elections. Is there something wrong with saying, these are people I trust and they like this guy or this woman, and that's who I'm going to vote for judge? In other words, again, the value of politics and making a judgment. I trust these people, this Democratic club, this Republican club, whatever it is.
That's a good thing.
I'm saying, is there,
of course, if you
at least there's some information.
Right. Of course, if you look
that may be the only information that somebody has about a judicial candidate is that this person's for.
But when you walk into the booth for a judge, in most of the state, there isn't a choice to be made in most places. There's lots of cross endorsement, or there's 3 candidates for the Democratic Party, and there's 3 slots, and it's a foregone conclusion who's going to win this.
That's not the experience, though. I think at least in Brooklyn, where I know that there have been challengers, much more so than in St. Manhattan. Pardon my speaking about. But in Brooklyn, you have very strongly contested civil court elections.
That's right.
I was talking about the Supreme Court elections. I wasn't talking about civil court.
But the Gleason decision is talking about throwing that system, at least on an interim basis, into a civil court style system, which brings me back to the question of whether the cure is worse than the disease. Let me take, do you have a question? No, I'm sorry. So, again, throwing me back into that question that is the cure worse than the disease? This is an interim decision. We don't have much time left. How do you view Judge Gleason as trying to craft a longer-term solution? He's asked the legislature to do it. Absent the legislature's action, would you be going back to him and ask him to have a specific solution?
If the legislature doesn't step up and do something, then the judge finds that this is an unconstitutional system, the judge has no choice but to craft some sort of remedy for the constitutional.
Do you think that's appropriate
remedy
for a judge,
for violation,
for a federal judge to decide how the people of New York
if the legislature won't do it,
but we do
then,
it. But wait a minute.
then
We
the
do
judge
it all
has
the time.
has to vindicate people's constitutional rights. That's entirely the judge's role.
We do it all the time in civil rights cases. That when a federal judge finds something constitutional, the rule is unconstitutional. My understanding of the case law is the judge then says it's unconstitutional. I'm going to give the political subdivision an opportunity to solve it.
Which is what he did.
Well, no, that's not what he did. What he did was he promulgated a remedy, and then he tried to impose that remedy this year. And only as a result of you backing in and working out a stay. But all in January, February, and March, people thought that they were running, actually it wasn't that early because the decision came down in February, but early on, people thought that they were running under Judge Gleason's solution. Clearly his decision...
this is going to be in place till the legislature acts.
But
the legislature could have acted this session,
but
and
clearly
it would have gone
he shouldn't
away.
even have done that. His decision that the remedy, if the legislature doesn't act, is premature. Okay? I have done, in every civil rights case I have read, judges do not rush to judgment with a remedy. Even more importantly than that, judges even allow time for when the legislature makes its decision, they even allow for people to come before the court, amici briefs, people move to intervene on the issue of remedy.
And there was in this case.
There was
in this
there was
case,
no time.
and there was no alternative suggested by the defendants.
There's only a minute left. Go ahead.
No, he entertained the issue of remedy before he issued the decision of unconstitutionality. That's the point I'm saying. Most judges say it's unconstitutional, it's bad, boom. Now, what are we going to do about it?
It's certainly not
and
appropriate.
then there's an issue
it's certainly not
where
appropriate
people
for a federal judge to decide how the people of New York
Let me
elect
let them.
their judges.
I'm sorry.
Then you leave,
Let me let you have the last about 15
then you
seconds.
leave the
legislature.
violation with
Let
no
her have the
remedy,
last
and you
word.
might as well not have a
That's
constitutional
not true.
right
You
at
don't
all.
leave it with remedy. What you do is you give people time. You
I've
give
lost
people
control.
time. You give people.
You have
don't
4
leave
lawyers.
it
It's time
open-ended.
for me to say goodbye. I got the goodbye sign. I always make deadlines. We will continue this conversation.
Sorry
Thank you
about
very
that.
much. No, it's great. I love it. We'll continue this next time on the CUNY Forum.
Oh, okay.
Thank you.
Thank you.
Thank you.
Thank you.
Sit still. Sit still. Sit still. Until they...